Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we are going to discuss the topic that is post-independence judicial tests on sedition. Dear learners, the objectives of the present module are: number 1, to discuss the judicial test on the sedition law. Secondly, to discuss the constitutionality of the sedition law with the help of landmark judicial decisions delivered after independence. Before delving deep into the topic, let's have an overview of the topic. In the previous modules, we have discussed that sedition was not a part of the original Indian Penal Code, which was enacted in 1860 by the British government. It was introduced in 1870 to quell the freedom struggle and retain imperial power. After sedition was introduced as a crime, British courts in India convicted Bal Gangadhar Tilak, Annie Besant and Mahatma Gandhi, and many other freedom fighters also. Gandhi, after his prosecution in 1922 for sedition, said that Section 124A is perhaps the prince among the political sections of the Indian Penal Code designed to suppress the liberty of a citizen. The word sedition has not been defined in the Constitution. Section 124A, which is part of Chapter 6 of the Indian Penal Code, deals with offences against the state. It defines sedition as whoever, by words either spoken or written, or by signs, or by visible representation or otherwise, brings or attempts to bring in hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. Disaffection includes disloyalty and all feelings of enmity. When comments disapprove of government measures, but with a view to alter them lawfully, that is, comments expressing disapprobation of the measures of the government with a view to obtaining their alteration by lawful means, without exciting or attempting to excite hatred, contempt or disaffection. Then, when comments disapprove of government's administrative actions without exciting all feelings of enmity, that is, comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection. Dear learners, let's discuss post-independence cases on sedition. Many sedition cases booked since independence have failed to withstand judicial scrutiny, except in Kedarnath versus State of Bihar, where the Supreme Court upheld the charge with certain caveats in 1962. Firstly, we will analyze rulings on sedition prior to Kedarnath Singh's judgment. The judicial decisions prior to Kedarnath Singh's judgment include: firstly, Ramesh Thapar versus the State of Madras 1950. After independence, although certain observations were made by the court in Ramesh Thapar versus State of Madras and Brij Bhushan versus State of Delhi, the question of constitutionality of Section 124A did not directly arise before the Supreme Court until 1962. The majority in Ramesh Thapar held that unless a law restricting freedom of speech and expression is directed solely against the undermining of the security of the state or the overthrow of it, any such law restricting the same cannot fall within the reservations under Article 19 Clause 2. The Apex Court held that a law that restricts speech on the ground that it would disturb public order was unconstitutional. The decision of the court prompted the first Constitution Amendment, where Article 19 Clause 2 was rewritten to replace undermining the security of the state with in the interest of public order. Another significant case is Brijbhushan and another versus the State of Delhi 1950. The judgments in both Ramesh Thapar and Brijbhushan were delivered on the same day. The same majority in Brijbhushan relied upon its decision in Ramesh Thapar and struck down Section 9 Clause 1A of the Madras Maintenance of the Public Order Act 1949, which had authorized the imposition of restrictions on the freedom of speech and expression for preventing or combating any activity prejudicial to the public safety or the maintenance of public order. The majority held that the impugned provisions were in excess of the powers conferred on the legislature by Clause 2 of Article 19 of the Constitution. However, Justice Fazal Ali, while writing a dissenting opinion in both of these cases, delved into the nature and scope of the law of sedition and explained the rationale for not including the term sedition in Article 19 Clause 2 of the Constitution. Thus, Justice Fazal Ali held that there were various degrees of gravity in the offence of sedition. The reasoning for the omission of sedition from Article 19 Clause 2, according to him, was the intent of the framers of the Constitution to include terms of wider connotation, which included the activity of sedition along with other activities, which are detrimental to the security of the state as sedition. In another case, Tara Singh Gopichand versus State 1951, one of the earliest cases, the Punjab Haryana High Court in this case struck down Section 124A of the Indian Penal Code, which defines sedition, holding it to be unconstitutional as it was contrary to the freedom of speech and expression guaranteed under Article 19(1)(a). The court held that it is true that the framers of the Constitution have not adopted the limitations which the federal court desired to lay down. The reason may be they didn't consider it proper to go so far. The limitation placed by Clause 2 of Article 19 upon interference with the freedom of speech, however, is real and substantial. The unsuccessful attempt to excite bad feelings is an offence within the ambit of Section 124A. In some instances, at least, the unsuccessful attempt will not undermine or tend to overthrow the state. It is enough if one instance appears of the possible application of the section to curtailment of the freedom of speech and expression in a manner not permitted by the Constitution. The Parliament, by the Constitution First Amendment Act 1951, amended Clause 2 of Article 19 and inserted two additional restrictions, namely friendly relations with foreign state and public order. The statement of objects and reasons of the Constitution First Amendment Act 1951 provided, During the last 15 months of the working of the Constitution, certain difficulties have been brought to light by judicial decisions and pronouncements, especially in regard to the chapter on fundamental rights. The citizens' right to freedom of speech and expression, guaranteed by Article 19, 1A, has been held by some courts to be so comprehensive as not to render a person culpable even if he advocates murder and other crimes of violence. Thus, the Parliament took note of the reasoning of the majority opinion in Ramesh Thapar, which had held that freedom of speech and expression could be restricted on the grounds of threat to national security and for serious aggravated forms of public disorder that endanger national security and not relatively minor breaches of peace of a purely local significance. The amendment echoed the statement of law as laid down in the dissenting opinion of Justice Fazal Ali in Brijbhushan's case. Now, subsequent to the enactment of the Constitution, First Amendment Act 1951, the Patna High Court in Devi Soren versus State of Bihar 1953 dealt with the validity of the section 124A. While upholding its validity, the High Court held that scope of Article 19 Clause 2 has now been widened after the addition of "in the interest of public order" as a reasonable restriction on freedom of speech and expression. The court, while distinguishing the terms public order and "in the interest of public order," held that while the term public order simply might need evidence of incitement of violence or tendency of violence, the expression "in the interest of public order" is wide enough to cover mere bad feelings without any proof of tendency to violence or disorder. 8 years later, in Ram Nandan versus State of UP 1958, the Allahabad High Court held that Section 124A imposed restrictions on the freedom of speech, which was not in the interest of the general public, and declared it ultra vires. Ram Nandan, who was fighting for the cause of farmers and agricultural labourers in UP, was charged with the sedition for an inflammatory speech on May 29, 1954, accusing the Congress rule of not being able to address extreme poverty in the state and exhorting cultivators to form an army and overthrow the government if needed. He accused the then Prime Minister Jawaharlal Nehru of being a traitor for dividing the country. These decisions were overruled in 1962 by the Supreme Court in Kedarnath, stating that any law which is enacted in the interest of public order may be saved from the voice of constitutional invalidity. The full bench of Allahabad High Court dealt with the constitutionality of section on 124A. While declaring section 124A unconstitutional, the court held that section 124A deals not with just the aggravated form of disaffection, but even for the mildest variety of hatred, contempt or disaffection. There could be instances where speech would contain the germs of an incitement to violence and instances where it would not. Thus, even a mildest form of disaffection could be caught by section 124A, which would go against the scheme of Article 19(1)A of the Constitution. Then in Kedarnath Singh versus State of Bihar 1962, the constitutional validity of Section 124A was put to a test in this case. A member of a forward bloc had given a speech which was charged as sedition. The Supreme Court held that speech or writing to which subverting the government by violent means is implicit, including the notion of revolution, is seditious. A failed attempt to incite too is counted as sedition. It was seditious to create public disorder. No unreasonable distinction between criticism of the government mayors and criticism of the government itself was drawn. Kedarnath was a member of Forward Communist Party of Bihar and was charged with sedition for accusing the Congress government of corruption and targeting Vinoba Bhave's attempts to redistribute land at a speech in Barauni in 1953. A 5-judge bench of the Supreme Court, headed by Chief Justice B.P. Sinha, upheld Section 124A, stating that it is intra-virus. Justice Sinha, however, laid down certain caveats. He observed, comments, however strongly worded, expressing disapprobation of the actions of the government without exciting those feelings which generate the inclination to cause public disorder by acts of violence would not be penal. In other words, disloyalty to the government established by law is not the same thing as commenting in strong terms upon the mayors or acts of the government or its agencies, so as to ameliorate the condition of the people. The court hence struck a balance between the right to free speech and expression and the power of the legislature to restrict such right by observing the security of the state, which depends upon the maintenance of law and order, is the very basic consideration upon which legislation with regard to punishing offences against the state is undertaken. Such legislation has, on the one hand, fully to protect and guarantee the freedom of speech and expression, which is the sine qua non of a democratic form of government that our constitution has established. But the freedom has to be guarded against becoming a license for vilification and condemnation of the government established by law, in words which incite violence or have the tendency to create public disorder. A citizen has a right to say or write whatever he likes about the government or its mayors by way of criticism or comment, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder. The Supreme Court in Kedarnath Singh took note of its earlier decision in Ramji Lal Modi to observe that the latter judgment throws a good deal of light upon the ambit of the power of the legislature to impose a reasonable restriction on the exercise of the fundamental right to freedom of speech and expression. The Supreme Court took note of the strict test of proximity as laid down in Ramji Lal Modi and reinterpreted in Ram Manohar Lohia's case. Thus, while laying down the test for sedition, the court held that unless the words used or the actions in question do not threaten the security of the state or of the public or lead to any sort of public disorder, which is grave in nature, the act would not fall within the ambit of Section 124A of Indian Penal Code. It is pertinent to note that as per the Kedarnath Singh's judgment, proof of violence is not essential for establishing the offence of sedition. As to the nature of the test laid down in this case for determining the threat to violence, Kedarnath Singh indeed approved the tendency test of the United Kingdom, rather than relying on the imminent danger test of the United States. This is so because throughout the judgment, focus is on the tendency or incitement to violence or disorder, rather than actual violence or imminent threat of violence. That the accused Kedarnath Singh was convicted and punished for his speech without any proof of direct incitement of violence or any imminent danger of public disorder is further testimony to the court adopting the tendency test for the interpretation of section 124A of Indian Penal Code. Then in Balwant Singh versus State of Punjab, 1995, another important judgment. Balwant Singh, who was the Director of Public Instructions in Punjab, Chandigarh, among other two, was alleged to have shouted pro-Khalistan slogans on the day of former Prime Minister Indira Gandhi's assassination. The apex court held that unless there is public disorder, merely sloganeering can't attract punishment under section 124A. The Supreme Court held that the casual raising of the slogans once or twice by two individuals alone cannot be aimed at exciting or attempting to excite hatred or disaffection towards the government as established by law in India. The duo had raised anti-India slogans on October 31st, 1984, the day Indira Gandhi was killed. In Bilal Ahmed Kalu versus State of Andhra Pradesh, 1997, the court quashed the charges under the said section, as it was not established before the court that the appellant had done anything which would threaten the existence of the government established by law or might cause public disorder. In Nazir Khan versus State of Delhi, 2003, the Supreme Court retreated the principle by stating, sedition has been described as disloyalty in action, and the law considers as sedition all those practices which have for their object to excite discontent or dissatisfaction, to create public disturbance or to lead to civil war, to bring into hatred or contempt against the sovereign or the government, the laws or the constitution of the realm, and generally all endeavors to promote public disorder. In Common Cause versus Union of India, 2016, a prayer was made in this case to issue directions for review of pending cases of sedition in various courts, where a superior police officer may certify that the seditious act either led to the incitement of violence or had the tendency or the intention to create public disorder. The court guaranteed the prayer and directed the authorities that while dealing with section 124A of Indian Penal Code, they are to be guided by the principles laid down in Kedarnath Singh's case. Recently in Vinod Dua versus Union of India, 2021, affirming the law laid down in Kedarnath Singh, the court held that a citizen has a right to criticize or comment upon the measures undertaken by the government and its functionaries, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder, and that it is only when the words or expressions have a pernicious tendency or intention of creating public disorder or disturbance of law and order that section 124A can be invoked. In S.G. Vombatkare versus Union of India, 2022, in its order dated May 11, 2023, the Supreme Court directed all the state governments and the central government to keep all pending trials, appeals and proceedings arising out of charge framed under section 124A to be kept in abeyance. The court, in its prima facie observation, opined that the rigors of section 124A of IPC were not in tune with the current social milieu and were intended for a time when this country was under the colonial regime. A Supreme Court bench on 3rd February 2021 junked a petition seeking action against former Jammu and Kashmir Chief Minister Farooq Abdullah for his comments over scrapping of Article 370 and bifurcating Jammu and Kashmir into 2 union territories. The apex court stated it is not seditious to have views that are different from the government's point of view. This brings sedition law in India under focus. My dear learners, on the basis of foregoing discussion, we may sum up that the sedition law keeps a check on anti-national, secessionist and terrorist elements that can hamper the public order and incite violence and induce enmity. As the seeds of sedition law were sown in colonial times, it is often described as a draconian law that can be used against what is otherwise is constitutionally guaranteed freedom of speech and expression. It has an ill effect on constructive criticism. As noted by the Supreme Court, views that are different from the government's point of view do not mean sedition. Therefore, sedition laws can demotivate lawful criticism. To penalize the offender for disrupting public order, Indian Penal Code and Unlawful Activities Prevention Act 2019 have adequate provisions that can take care of the punishments. My dear friends, with this I conclude my lecture. I hope you find it beneficial and it enriches your knowledge. Thank you very much.